Human rights lawyer Ted Tess says 5 years after the Supreme Court decided cyber libel is constitutional, the charges against Rappler and its CEO Maria Ressa are bringing up issues that may prompt a revisit of the once hotly contested law. Te and the Free Legal Assistance Group, or FLAG, have taken on the cyber libel case against Rappler, Ressa, and the writer of the disputed article, former researcher Ray Santos Jr.
Basically, two specific grounds: that the charge, the information, does not state an offense, that cyber libel is not an offense as pleaded in the information, for many reasons, among which is that it has prescribed. Second is that there is no multiple republication rule in the Philippines as far as cyber libel is concerned.
Ressa and Santos were supposed to be arraigned on Friday, but the schedule was reset to give time to the Department of Justice to respond to the motion to quash prepared by FLAG for Rappler. Complainant and businessman Wilfredo Keng was represented only by lawyers. Keng's lawyer Ryan Cruz says this is a, quote, wake-up call for all media outlets to be judicious and responsible in their reporting. While the Rappler article was published in 2012, or months before the Cybercrime Act was enacted, and a complaint was filed only 5 years later, the DOJ still charged Rappler for cyber libel because it considered the typographical edits made on February 19, 2014 as continuous publication. They argues that on that date, the TRO was still in effect, so there was no law to apply this republication rule.
It's ridiculous that Rappler and I have had to face at least 10 cases in the span of about a year, that I've had to post bail 6 times, and to be arrested and detained based on a cyber libel law that A, didn't exist, and B, even if you go by what the charge sheet says, may TRO nga eh, wala pang